Hi, this is Attorney Feng, immigration lawyer from New York City. Today, we're going to talk about the statistics information that will shock you. For EB2 and EB3, labor certificate-based green card application, if you go through consular processing for the last step, the denial rate is 61%. Which means 61% of the case could not go through the last step, and they are going to be denied by the U.S. consular officer. However, compared to if you do it in the United States, go through adjustment of status processing, only 4% of them were denied. Why there's a huge differences in terms of two different processing for the last step based on the same approved cases. EB2 and EB3 labor certificate-based green card application have 3 steps. First, Department of Labor adjudicates your labor certificate application. Second is after the first step is approved, USS will adjudicate I-140 processing. The third step depends on where you are. If you are in the United States, you will do adjustment of status in the United States. If you are outside of the United States, you will go through consular processing. That's where 60% of the applicants were denied from 2019 to 2020. Consular officers have not disclosed the reason of such denial and high rate of the denial, but a retired consular officer disclosed that under the circumstances, if the applicant has never worked for the employer, has never been in the United States, and if they have not worked in the same field, they would assume this job is not a good fit job offer. Ironically, the law does not request the benefit to be in the United States to have working experience with the sponsor, because this is not for current employment. The green card application is for future employment, and the sponsor is allowed to sponsor somebody who has never been in the US for green card application. If at one hand, the law allows you to do it, on the other hand, the consular officer has his own interpretation on the law to assume there is abuse of the system, then who is going to win? The consular officer can do their decision above the law. You have all the right to doubt whether there is a good faith job offer, but at least you can conduct your investigation to confirm the job. So we would suggest all the benefit, if you are going through the consular processing, talk to your sponsor, let your sponsor has a designated staff to answer consular officer's call, to respond the email, to verify your employment. And no response will cause the denial of your immigrant visa because they are not going to believe there is a good job offer in it. And another suggestion is you could enter USCIS and go through the adjustment of status. As long as you meet adjustment of status requirement, you can go through that processing instead of going through consular processing. Hope today's tips are helpful and wish everybody good luck.